Very much, Mzee. Colleagues, let me just introduce our panel. It's only two people: Minister of Justice and Correctional Services, Advocate Michael Masutha, and next to him is our acting National Commissioner of Corrections, Mr. Zach Modise. The rules of engagement are very simple. Minister will take us through his statement, after which we will indulge in question and answers linking up to Cape Town as well. For the record and for the purpose of those who don't know me, my name is Mthunzi Maga. I'm the spokesperson for the Ministry of Justice and Correctional Services. Minister, over to you. Thank you very much.
Well, thank you, Mthunzi, and Commissioner, for your support. Members of the media, fellow South Africans, today I announce my decision on the parole application of Messrs. Freddie Barnett, Eugene Kock, and Clive Lewis, inmates incarcerated in our correctional centers and serving sentences for various crimes. All these matters have attracted publicity here and abroad because of the severe impact caused by the crimes they committed, which are well documented. It is for this reason that we elected to communicate my decisions in this platform. Inasmuch as the timing of these decisions is informed by court orders of the North Gauteng High Court, which were based on an agreement between the legal representatives and my office, it is important to indicate that all these parole applications were under consideration by relevant structures within correctional services. Let me also take the opportunity to thank the President of the Republic for the support he has afforded to me over the past few months since my appointment into this position, including the advice that he gave me early in my appointment, namely that in all matters that are before me, I should be guided by the rule of law and the Constitution. And that's exactly how I have conducted, or that's exactly how I've conducted myself in my office so far. Now, starting with Mr. Freddie Barnett, on 4 June 1998, after being found guilty of having committed serious crimes, including the murder of Dr. David Webster, who was an anthropologist at the University of Witwatersrand, Mr. Barnett was sentenced to 2 terms of life and 63 years imprisonment. That particular murder was committed whilst Mr. Barnett was on parole for a previous murder. On 28 November 2014, he applied to be released on parole. Whilst his application was due to be considered by the relevant structures within correctional services, he approached the North Gauteng High Court in a bid to have his application considered and a decision made by me within a specified period of time. However, an agreement which became an order of court was reached by parties. The court order required the National Council for Correctional Services, the NCCS, to consider the application on or before 19 December 2014 as required by the law. In terms of the said order, I am required to make a decision on or before 31 January 2015. This means that I could only make my decision once I had received the recommendation of the NCCS and the profile of Mr. Barnett. The NCCS has written to me indicating that they needed more time to consider the application and the profile, and are therefore unable to submit recommendations to me within the stipulated time frame. This means that I am unable to make a decision in terms of the court order. In this regard, I am advised that arrangements have been made between the legal representatives of the parties to have the order varied and the dates extended. I am also advised that all concerned have agreed to such extension. In the circumstances, no decision has been made on Mr. Barnard's parole application. I now turn to the matter of Mr. Eugene Alexander de Kock. In respect of Mr. de Kock, you will recall that in July 2014, I declined to place him on parole, as at the time the victims and their families had not been consulted as required by law. I had directed that a further profile be resubmitted not later than 12 months in order to afford victims, the offender, and other relevant structures time to participate and finalize all outstanding processes. I've now reconsidered the matter and noted the various positive reports compiled by the relevant professionals and bodies. I've noted the progress he is reported to have made to improve his skills whilst in custody, as well as the assistance Mr. de Kock is said to have provided and continues to provide to the Missing Persons Task Team of the National Prosecuting Authority, the NPA. I'm also satisfied that comprehensive consultations with affected families has been done. My decision is therefore informed by all these important factors. However, I need to remind all of us that parole does not reduce the sentence imposed by the court. Offenders who are placed on parole are expected to comply with the set conditions, and failure to comply with this may result in the offender, depending on the frequency and seriousness of the violations, having his or her parole revoked to serve the remainder of the sentence in a correctional facility. Also, in the interest of nation building and reconciliation, I have decided to place Mr. de Kock on parole. He has requested that the actual date and conditions of his release should not be made public. I have acceded to this request and plead with members of the media to respect that request. I turn now to Mr. Clive W. I will now deal with the medical parole application of Mr. Clive W. Mr. W. is serving life imprisonment at Kgoshi-Mampuru, the 2nd Correctional Center, following his conviction for murder for the killing of former South African Communist Party, that is SACP Secretary General, Mr. Chris Hani, in April 1993. On 9 July 2014, his application for placement on medical parole was considered by the Medical Parole Advisory Board, the board, and he was found to be suffering from lung cancer and undergoing chemotherapy. The board could not agree on whether the cancer was spreading, and therefore decided that he should continue with chemotherapy to assess the effect thereof. The board also decided to engage other specialists to examine him and provide an independent opinion on the nature and extent of his ailment. In November 2014, the offender brought a court application for placement on medical parole. Mr. Hani's widow, Mrs. Dimpo Hani, and the SACP joined the court proceedings as interested parties. On 2 December 2014, the court made an order in terms of which I was directed to make my decision on the matter on or before 31 January 2015. The order also required the board to consider his medical parole application and make written recommendations to me on or before 15 December 2014. The board has made a recommendation that I should place the offender on medical parole. I have now considered the offender's application. In making my decision, I took into account the applicable legislation, recommendations made by the board, as well as the submission made by Mrs. Hani and the SACP. Our country is a constitutional democracy which is governed by the rule of law. Therefore, in reaching my decision, I have taken into account the relevant laws and prescripts that regulate the medical parole process, in particular the provisions of the Correctional Services Act 11 of 1998 and the regulations promulgated thereunder. This legislative framework guides the Medical Parole Advisory Board and me in considering an offender's application. Section 79(1) of the Act provides that a sentenced offender may be considered for placement on medical parole by, among others, the minister if A, such offender is suffering from a terminal disease or condition, or if such offender is rendered physically incapacitated as a result of injury, disease, or illness so as to severely limit daily activity or inmate self-care. B, the risk of reoffending is low, and C, there are appropriate arrangements for the inmate's supervision, care, and treatment within the community to which the state is to be to which the inmate is to be released. Regulations 29A of the Correctional Services Regulations GNR 323 of 25 April 2012, published in Government Gazette 35277 of the same date, provides for medical conditions for which an offender can be considered for placement on medical parole. Sub-Regulation 5 provides as follows, and I quote, "In the assessment by the Medical Parole Advisory Board, the board must consider whether the offender is suffering from," and paragraph B, non-infectious conditions, Roman figure 1, malignant cancer stage 4, with metastasis being inoperable, or with both radiotherapy and chemotherapy failure. In its recommendation, the board states that Mr. W. Lewis is suffering from stage 3B, cancer of the lung, and this serves largely as a basis upon which it recommends his placement on medical parole. This finding and recommendation appear to be oblivious of the fact that in terms of the Act, read with the relevant regulations, it is an inmate with malignant cancer stage 4, with metastasis being inoperable, or with both radiotherapy and chemotherapy failure, that qualifies for placement on medical parole. The rationale of the board's conclusion in this regard is, on the face of it, difficult for me to comprehend. There is nothing to suggest that Mr. W. Lewis Mr. Darby Lewis's condition is such that he is rendered physically incapacitated as a result of injury, disease, or illness so as to severely limit daily activity or self-care as provided for in the Act. Upon further perusal of the medical reports, I established that the name on the pathologist's report is not that of offender Clive Darby Lewis. In an affidavit he submitted to the board, he states that he used a different name for security reasons. It also appears from his affidavit that coincidentally, another patient bearing the name used by the offender was admitted at the same hospital during his admission for treatment of a similar medical condition. This prompted him to revert to an earlier pseudonym that he had used when he was first admitted. It must be stated that there are no supporting documents attached from the department in support of these name changes. This raises uncertainty on the identity of the patient whose samples informed the recommendations of the board. I'm also not satisfied that requirements of Section 79(1)(b) have been complied with, as there is no indication on the profile as to whether the offender has shown remorse for the crimes committed. In the circumstances, the board's recommendations to place the offender on medical is not approved. This decision will be communicated to his legal representative as required by the court order. I now turn to another matter, and that relates to the political pardon process that had been pending for some time before us. You will recall that a special dispensation was adopted in 2007 in order to facilitate the granting of presidential pardon for alleged political offenders in terms of Section 84(2)(j) of the Constitution of the Republic of South Africa, 1996. After consultation with the Office of the President, we have resuscitated this process, and it is now at an advanced stage. We shall announce details of this process in due course. In the meantime, the Department of Correctional Services is finalizing the processing of parole applications for all the remaining offenders who were identified for consideration under the said dispensation in order to expedite their possible release on parole. I thank you.
Thank you very much. Thank you very much, Minister. Ladies and gentlemen, in Cape Town and in Pretoria, it's now time for Minister to indulge you in your questions. We will start here in Pretoria. I need to indicate, though, that when we are done with the briefing and the question and answer, Minister is generous enough to afford you on one-on-ones later on. And I also need to explain that part of the statement that relates to Mr. de Kock, there's an indication of his request that details of the date of release and other conditions should not be made public. So Minister will not indulge you on that one. So don't even attempt to interrogate that aspect of the statement. Only confine yourself to the decision itself. We will start here. Introduce yourself in the media house you are representing. Karen.
Good morning, Karen Morn from eNCA. Just a question for the Minister. There's no sense in which you're disputing that Mr. Darby Lewis has cancer. You're just raising concerns about the samples and the stage of that cancer. Is that correct? And second of all, you know, in terms of an end game, does the Correctional Services Department have a degree of discomfort about the fact that Darby Lewis may in fact die as a prisoner. Would you want to see him released before his death, or is that something that's not being considered at this point? Thank you.
Thank you, Karen. Sir.
Angelo Coppola from China Central Television. It's a follow-on question to what was just asked now. Are you saying that the pseudonym that Darby Lewis actually lied and that the samples aren't actually his? Just on a point of clarity.
Okay. I don't seem to see any other hands. All right. Thank you. Mzi, do we have hands in Cape Town?
No. Yeah, we have one. We have one, Mchura.
Okay, that's good. Let's take it.
Janet Hurd, Media 24. With regard to Ferdy Barnard, could you just clear up what deadlines were set, or if anything, new deadlines set before a decision will be made? Thanks.
All right.
That will be all for this round, Mchura.
Okay, Minister, can you indulge them, please?
Karen, eNCA, thank you for the question. I can only work with what is before me and what is on file, and make an assessment and take a decision on that basis. I do not have before me, in my view, sufficient information or evidence to corroborate the claims that Mr. W. Lewis is making, that indeed his version is correct. And the circumstances are particularly, if there is an element of coincidence, it would certainly be a very strikingly strange coincidence. That, pardon me, a person gets admitted to a hospital, uses a pseudonym of somebody who actually exists, and upon his treatment, that person who actually exists gets admitted for treatment for a similar medical condition that he is being treated for at the same hospital during the same time that he is receiving that treatment. And the results come in the name or names of that other person and are attributed to Mr. W. Lewis, which then, according to his own affidavit, compels him to revert to an earlier pseudonym that he had been using. The whole story is so confusing and very suspect, and I would have preferred a situation where the only evidence before us is not just his own affidavit supported by a mere doctor's statement, which is not in the form of an affidavit either. So I just felt that the circumstances created sufficient doubt for me not to feel confident to make a decision on the basis of that assertion from him. Equally with regard to the state of his health, you'll recall that in July, the same Medical Parole Board, something we may not have mentioned, decided 6 against 3 that his medical condition did not qualify him for medical parole, that he was still stage 3B and therefore did not meet the stage 4 requirement stipulated in the law. And it was for this reason that, because they had a split decision, because there were 3 who supported stage 4, that they called for a team of experts to give them a second opinion, as I understood it. That report that was received from the experts also produced a split opinion, as I understand it. Two of the three experts, I understand, confirmed stage 4, but one of the professors had doubt, serious doubt in this regard. I'm made to understand that his own doctor also confirmed stage 3 and improving. Now, the board itself, in its report, confirms stage 3B. And it does not apply its mind to all, well, it does not make findings, specific findings with regard to all the other elements that are prescribed by the Act, which are preconditions for a person to qualify. But over and above that, its own finding is that he is at stage 3B, which is not the stage that the law prescribes as the prerequisite for medical parole. So in the circumstances, it's not clear to me how the board then jumps to a recommendation that disregards these matters, recommending that he be released on medical parole. Now, you asked the question, what if something happens to him? Look, I firstly am not a medical practitioner and depend entirely on the information that is placed before me by experts. And therefore, it is not my province to make a personal or emotional opinion that is not informed by the facts that are presented before me. None of us can determine when our day will be. I can tell you of my own mother a year and a half ago, who, when I met, consulted with her doctor, he told me that she had another 5 years to live. And I left the hospital pleased that 5 years for a person of her age was as good as a lifetime, only to receive a call the following day that she had passed on. So none of us, even doctors, can predict with absolute certainty when our day comes. And I'll leave it at that. Thank you. As regards the other questions, the issue of samples, I think in a sense I've covered that point from the journalist from China TV. And the issue of deadlines, I am not privy at this stage as to the exact agreements reached between the parties. All I know is that at this point in time, as I speak, I do not have before me, contrary to the order which required the NCCS to consider the matter in December last year and to make recommendations to me to enable me by tomorrow the 31st to make a decision on the matter of Mr. Fedi Barnett. I do not have before me as we speak a report with findings and recommendations from the NCCS for my consideration. So as a result, as we speak, I am unable to comply with that court order because there's nothing before me to enable me to do so. As to what the agreements between the NCCS and the attorneys on the other side have reached, I have no knowledge thereof, and I would rather not speculate in that regard. Thank you.
Thank you very much, Minister. We'll allow the last round unless Minister was clear enough and were able to absorb the well-informed and well-crafted statement that he just presented. Okay, maybe not. Yes.
Sorry, Mtura, can the colleague use the mic?
Can you switch on the mic, please, Christine? Thank you very much.
Sorry, I'm being a conference room noob. Kristen from Agence France-Presse, is the Minister at all concerned about any safety issues regarding Mr. de Kock's release?
Next to you.
Minister Avumile Qonqo from Africa News Network. Well, the apparent documents fraud by Derby Lewis in this application is likely a criminal offence, or is it? And also, will the minister refer the matter to the NPA for prosecution?
Patricia, I thought you had your hand up.
Zinego Mshaba from Soweto TV News. Minister, I would like to find out how influential is the public opinion on this issue, considering the issues of reconciliation and stuff like that, and how vital was that point in your decision?
Is it in reference to Mr. De Lewis or Eugene Kock, or all of them? Mzee, do you have any questions in Cape Town, or you guys are sorted? Thank you very much.
Mtura, we are sorted. Our questions were taken.
All right, thank you. Pretoria, you will not have any other opportunity now. It's now or never. Minister, over to you. Thank you.
Thank you for all the questions. Christine, on the security issue regarding Mr. W. Lewis, sorry, Mr. Eugene de Kock, let me indicate that the primary reason, as we understand it, why Mr. de Kock requested that he needed time to make appropriate arrangements before the date of his release was made public, was essentially to enable him to settle in, or rather to make all necessary arrangements for him to be able to settle in upon his release, and so on. I do not understand the primary reason to have had anything to do with security considerations at this stage. As far as the possible fraud question, fraud charges in respect of misrepresentations of identity, that is a matter which at this stage is not being looked at as such, but should need arise or justification arise for it to be looked at as such. Obviously, that will be done because we believe in upholding the rule of law. Nobody is above the law, and therefore, if anybody commits an offense, they have to take accountability for their actions. As far as the issue of public opinion is concerned, I have indicated earlier deliberately, which is not part of my written statement, that early on in my appointment, when seeking counsel from the President, he advised me on various matters. He advised me that in all decisions I make, I must be guided by the Constitution and the rule of law. And I took heart from that, and that's precisely how I have conducted myself in office since my appointment. Thank you very much.
Ladies and gentlemen, I indicated that, Minister, for those that want to adopt different angle and explore, he will be available for one-on-ones. Just indicate where and when you want that to happen. And for the whole day and the evening, he's ready to go to any studio to indulge you on his decision. Because like I said, this is a well-crafted and well-researched and well-informed decision. That's why you even asked only 5 questions. Thank you very much. Minister, thank you.
Thank you very much, Twinsie, and thank you all for coming.